Case number 118378 in the matter of Lance Haley.
May it please the court, Kate Baird, Deputy Disciplinary Administrator, appearing for the Disciplinary Administrator's Office. Mr. Chief Justice, may I reserve 2 minutes for rebuttal, please?
2 minutes is granted.
Justice Ness, Mr. Haley, Justices, this matter is before the court this morning as an original action in attorney discipline. There was a hearing held, a panel convened in May of 2017, considering allegations that the respondent had engaged in violations of the rules of professional conduct. There was no dispute at the time as to the facts or the rules violations. That is, no dispute between the respondent and the Disciplinary Administrator's Office concerning the facts or the rules violations. So the question before the panel at the time is, what was the appropriate discipline to recommend to this court? The hearing panel issued a report in September of 2017 finding that the respondent had engaged in violations of the rules of professional conduct. They recommended that this court impose a 1-year disciplinary suspension, but recommended that probation be granted for a period of 2 years. No exceptions were taken to that final hearing report, so the issue before the court is similar that as to sanction. What is the appropriate sanction in this case? I noted that there was no dispute between our office and the respondent concerning the facts. For the purpose of both our audience and any individuals that might be watching, I'll briefly address the facts.
Before you do that, counsel, I just want to understand, you mentioned what the recommendation of discipline was from the hearing panel. There's a line on page 14 of its final hearing report about recommending the respondent remain on probation until specifically discharged. That sentence just sort of stuck out to me. If it's a 2-year suspension or a 1-year suspension or a 2-year probation, I mean, if we have a term on a discipline of some sort, often it can end without some kind of order?
By rule, even if there is a designated term of probation, probation remains until a respondent seeks discharge.
Given that, is that just kind of excess verbiage?
I think it was for clarity.
Okay.
Because part of the complexity of this case is that the respondent has not yet sought administrative reinstatement.
Right.
His license was suspended administratively back in 2007. So for a 24-month period, we're not exactly sure when that supervision might begin, because I'll be asking this court to enter its order of suspension, but stay that suspension and direct that he be placed on probation when you order him reinstated, and we don't know exactly administratively, and we don't know exactly when that might be.
Okay, thank you.
So I did note that they recommended that the probation be made retroactive. I suppose conceivably, if there was no petition or application for the court for administrative reinstatement, that could go beyond that 24-month period. We don't know when that might happen. Okay. I think it is important for the respondent to be aware that by rule, and I think the recommendation of the hearing panel was to be certain that he would be on supervision until this court directs that he be discharged from that. Okay. And I pointed out one of the complexities of this case is the fact that the respondent was administratively suspended in 2007. The facts giving rise to the misconduct aren't that complex. In 2013, Mr. Haley notified our office in writing that he had been sanctioned in the Eighth Circuit Court of Appeals and by the state of Missouri for misconduct. That misconduct involved violations of 1.3 diligence, 3.2 expediting litigation, and 8.4 engaging in conduct prejudicial to the administration of justice. That arose from his representation of two individuals involved in an appeal in the Eighth Circuit Court of Appeals. He also informed us in that letter that he was looking at becoming reinstated. He did not have an active license in any jurisdiction in 2013. Ours was administratively suspended. He was under disciplinary suspension in Missouri. We opened up an investigation not only into the underlying misconduct that was reported, but also into his activities since his suspension in Kansas. During the course of the investigation, while on the Missouri side, he was seeking reinstatement actively with the state of Missouri. So in 2015, the respondent was reinstated. His license was reinstated on probation in the state of Missouri. We filed a formal complaint in January of 2017 alleging similar violations, basically a reciprocal action, finding that the other jurisdictions had concluded that he had engaged in violations of the rules of professional conduct. We also determined by way of a self-report through the course of the investigation that he had prepared a document on behalf of his mother in an estate planning matter that was, in our view, the unauthorized practice of law that was included in our formal complaint, as well as an allegation that he violated Supreme Court Rule 208. He provided to the panel and to our office a probation plan. The first probation plan actually proposed a Missouri lawyer, the lawyer that had been monitoring his probation in Missouri. There was concern that this court may not recommend or approve of a Missouri lawyer serving as a monitor in a Kansas case. So the hearing was continued from the original March date to May. Mr. Haley did present to the panel, a probation plan with a designated monitor. We did not oppose that probation plan, and today I've been provided an affidavit from the respondent indicating that he is in compliance, with the probation plan.
Counsel, this is really, I guess, just for clarification and not necessarily case specific, but there's a reference here to in the probation period that the respondent would continue to comply with the KLAP monitoring agreement. Do you actually see those monitoring agreements, or are they kept confidential with KLAP? And then you just rely on KLAP to tell you whether they're in compliance?
He has provided authorization to our office and to KLAP for them to provide information to us concerning his participation. I did see, and he presented to the panel, a copy of the monitoring agreement that he had entered into with KLAP. That monitoring agreement, though, I understand, and I have not seen a second agreement that was revised, because at the time of the hearing there was some concern and that the practice supervisor that was being proposed to our office and ultimately to this court would be Brian Leininger. He was also proposed to be the KLAP monitor and KLAP mentor. And I had a concern about perhaps a kind of a conflict between those two roles, because a supervisor would be expected to provide to our office or to the court concerns when a KLAP monitor might be serving in a different mentorship. So I understand, and I have confirmed with KLAP that there has been a second individual designated as a KLAP mentor, but I haven't seen a copy of that agreement.
Well, the affidavit says that's Eric Kraft.
That's my understanding. But I have not seen a copy of that agreement that's been entered into designating that he would serve in that role. This, during the course of this investigation, The respondent was quite candid about mental health challenges that he faced at the time that the conduct occurred, quite frankly, I think continues to face and recognizes that he continues to face those challenges. The hearing panel described a mitigating factor. They described it as unimaginable childhood trauma that has resulted in some challenges that he faces and is receiving treatment for. It's our recommendation to this court that you sanction the misconduct by a 1-year period of suspension, but grant probation from that, direct that he be placed on supervision, that he continue supervision for a period of 24 months, and that be made effective when the court reinstates his license administratively.
Counsel, on that point, I think I understand your recommendation. But I'm not clear when you think the 1-year suspension should begin. Because you're suggesting that the 2-year probation period not begin, as I understand it, until the respondent is no longer administratively suspended.
Right.
How does that impact the actual underlying 1-year suspension?
I'm hopeful that he will never have to have a 1-year disciplinary suspension. Because
I understand that, but let's just say hypothetically, we follow your recommendation and 12 months pass without him getting out from underneath the shadow of the administrative suspension. At that point, has he also served his 1-year disciplinary suspension? That's the question.
I would argue not. I would argue that that would not be the case.
So then we would have to somehow articulate that the disciplinary suspension also it extends at least 1 year past the time in which he is no longer administratively suspended. I'm just struggling with, if we follow your recommendation, how would that be articulated? I'm not sure I've seen that before.
Well, I was looking at some reinstatement orders to determine if there was some language in reinstatement orders that I could refer you to help craft an order for this particular case. I found, let's see.
And keep looking for that. I don't mean to cut you off, but just off the top of my head, it almost seems like what you're really recommending is an indefinite period of suspension. Because it's indefinite because we don't know when the administrative suspension might end.
If it's effective on issuance of our opinion.
Right.
But you're suggesting you want it, like the probation, to be effective on the date he's administratively reinstated. Isn't that language that would accomplish it? And is there an obstacle to that?
I don't see an obstacle
Well,
to
one
that.
obstacle I can see is that means that the day the opinion's issued, he's not under a disciplinary suspension.
He's not under a disciplinary suspension, but he is on probation.
Well, no, because he's administratively suspended.
Oh,
Yeah, I thought
Right.
that you said no,
You're right.
that you didn't want any of it to start until the day he gets administratively reinstated.
right. And I misconstrued your
Which may or may
question.
may never happen.
Right, it may never
Yeah,
happen.
may or
And that is.
That's why I was suggesting it's really kind of like you're asking for an indefinite suspension that will end 1 year after he gets his
That's the
his
problem.
license back.
It has impact though for reinstatement.
Right.
Because indefinite usually carries with it a minimum 3
Right.
years.
Yes, a minimum of 3 years, and that's really not what we would recommend to the court.
Right.
When we are looking at it strictly in terms of a disciplinary sanction, that would be a sanction that we probably would not recommend for this particular conduct. And I do agree, this is crafting the language and actually implementing the order of the court, an order of the court is the challenge. I think it's appropriate, or I would suggest it's appropriate to have some sanction in the event there is not compliance with probation. And if there is not compliance with the supervision, and that's a protection to the public. That's
See, I've always had a little question about that. As you noted, there's no automatic termination of probation.
Right.
And I thought our rules say something about the unsuccessful, being unsuccessful on probation.
They contemplate the circumstances.
So why do we need the suspension as a hammer if the rules contemplate that we can do something at that point anyway?
Well, if we were to if we had facts that we believed were a violation of probation, and we sought a revocation of probation was appropriate, then without that sanction, what do we assume the sanction is?
Well, what does the rule say? What does the rule say about? It says that my recollection was it says at the end of the probation, if it's successful, you seek a termination. But doesn't it also speak to the circumstance where it's unsuccessful?
If we are informed, if our office is informed of a violation, then there's a procedure that we are directed to follow to bring that matter to the attention of the hearing board or the board, and then potentially to the court seeking revocation of probation.
So the answer is that having the suspension already, or the consequence of a probation violation already determined, keeps you from having to come back and ask for a consequence.
Argue sanction, yes.
Yeah.
I guess I'm scratching my head a little bit here. If the respondent is administratively suspended right now, what's being monitored? I understand the KLAP part, but what's being monitored?
Right now,
Because he shouldn't be doing anything.
correct. I agree with that. I asked the panel, and I've confirmed with the monitor. The only thing I wanted that I asked be considered is the supervision that the monitor confirmed that he was not engaged in the unauthorized practice of law. He's on probation in Missouri, and he's practicing in Missouri.
Is this the same monitor as the Missouri?
No, different
Different.
monitor.
Or I guess you'd made that.
And that was another dilemma. I mean, how do you implement a probation plan when you're not practicing in Kansas? And I'm not sure it would have been a possibility, except that he was on probation in Missouri and was able to demonstrate that he was in compliance with the Missouri probation. So we have a Missouri probation. The plan was presented to our office and to the panel, demonstrating that he was practicing, that he was in compliance, that he was continuing treatment. So that did present another unique situation because he's not practicing in Kansas right now. But I did believe it was appropriate, if we were going to accept his proposed probation plan, to be confident that his proposed monitor would at least assure that he was not practicing in this state until he was reinstated.
And the proposed probation plan doesn't actually include getting off administrative suspension.
It does not include.
I mean, isn't that kind of a foundational part of this? Let's just cut to the chase. What are the hurdles and impediments? How hard is it going to be for a respondent to get off administrative suspension?
Well, at the time of the hearing, I understood it was 127 hours of CLE.
And the reason I ask this is why couldn't part of the probation plan or the conditions of probation just be shall come into compliance and get off administrative suspension by X date? Why isn't that a reasonable way or is it reasonable?
It may be reasonable. I did not consider that to be a condition of probation, that he, by a certain date, come into compliance or provide to the clerk of the court and CLE whatever requirements they had. And because of the length of because of the length of the administrative suspension, there may be other conditions imposed by this court concerning
Did you say the
proficiency.
administrative suspension started in 2007?
Yes,
I think the habit is once somebody's been out for 10 years,
Right.
sometimes there are greater demands in terms of
Right.
continuing ed. Although I think that's generally for people who have not been practicing law in the interim, and he has on the Missouri side, so
and, I'm sorry.
that may change that.
So one possibility that's been suggested is provide a date certain for him to get off of administrative suspension. And then, once that date occurs, if he has not gotten off, where are we?
If it is a condition of probation, then by rule, we would be looking at filing a motion to revoke probation and enter a 1-year disciplinary suspension.
And if he did comply by the deadline, let's say it's 30 days before the deadline, a proposal might be that at that point, the 1-year suspension goes into effect and 2 years of supervised probation. Okay.
Do you have any objection to this court imposing indefinite suspension with a statement in that order that we do not mean indefinite suspension as in 3 years, but indefinite suspension until these conditions are met?
Certainly, that would provide some clarity, and that would avoid the requirement of the rule that he go through a reinstatement hearing. So certainly, that I have no objection to that.
Any further presentation?
Nothing unless I did have a reference to the citation. Two reinstatement hearings, in re Susan Bowman, 303 Kansas 381, and in re Scott Stockwell, 304 Kansas P1. Now those include reinstatement language that I had anticipated coming into this hearing. There certainly may be better ideas and better thoughts on how the order could be articulated, but for the court's reference, those are citations that you might look at concerning language where reinstatement is effective upon certain conditions. Anything?
Any further presentation? Any more questions? Thank you, counsel.
Thank you.
May it please the court. Ms. Baird. Lance Haley appearing on behalf of the respondent, I am the respondent, I'm sorry, and proceeding pro se. Just some of this, I'm going to reiterate what she said. Pardon me if I'm being redundant here. And then some I'm going to add in so that the court is aware of what has been going on here the last couple of years in regard to my practice in Missouri. As Ms. Baird noted, and I think the court, I'm sure, has reviewed the record, I witnessed a horrific, violent incident when I was 7.5 years old. Ms. Baird had already requested that that be under seal, and my assumption is that you all have read about that. In 1996, I had my first major depressive episode. I'd been practicing law at that time for approximately 6 years. I was suicidal and depressed, went to seek counseling with Dr. Stephen Corey, who I subsequently then saw for 17 consecutive years. Not all the time, but that first year at least twice a week for a year, 2 years, whatever, and then after that usually once a month. There was a few segments of time in there where maybe I didn't see him for 4 or 5 months. He just told me come back on an as-needed basis, and I did. They put me on Prozac, my family doctor did at that time. I responded very positively, and from 1996 through about 2004, I essentially had no issues. During that time, my primary area of practice has been federal criminal defense in the Western District of Missouri. I handled both private cases and then eventually the court. A number of the judges down there asked me to start taking appointments. I turned that down initially, because I was so busy, but then Judge Moffmer wanted a favor, and when the judge asks you for a favor, you do it. In that interim, from essentially about 1999 through 2006, between both appointed and private cases, I handled, just in federal court, this doesn't count my state municipal practice, I handled close to 70 federal criminal cases, many of them complex. I took a number of them to trial. The judges had no clue that I was suffering. Some of them I was lead counsel in. And in 2004, I started what is called cycling. They doubled up my Prozac because I hit another wall. I was going up and down. By 2006, they realized there was something seriously wrong, my doctors did, and decided that I was bipolar, made the diagnosis, took me off the Prozac. I tried a complex criminal case that spring, almost acquitted my client, and then they put me on the lamotrigine. Had to start it out on a very long titration cycle because there can be severe and lethal side effects. It was during that period of time in that summer that I had several appellate briefs due with the 8th Circuit. I was down in a hole, waiting for this medication, praying that this medication was going to finally take effect, and it did, unfortunately, too little too late, and the 8th Circuit suspended me. At that time, I also had tax problems. I got reinstated with the 8th Circuit. I would note for the record, Missouri did a reciprocal suspension, and then obviously I surrendered my license to Kansas. I just let it go. I would note for the record that the Western District of Missouri, all of those judges, that panel down there, because of the length of time and the number of cases that I'd handled, and I never showed any problems, never suspended me.
You didn't, counsel, just to be clear, because these terms have meaning, you didn't really surrender your license, you just let the administrative suspension take effect.
I guess
and
that
there's a
was,
difference.
yes,
you
it
wanna,
is.
You don't want to confuse anybody here, so.
Yeah, I'm sorry, Judge.
No, that's
and
okay.
and
I
I
just wanna
would
make
note
sure
for I would note for the record, and I'm happy you brought that up. At the time that everything was happening over in Missouri, I was very quickly trying to wind down my practice. I had 7 federal cases that were going at that time. I found an attorney to take 6 of the 7. He had a conflict with the 7th. We found somebody. I was literally helping them meet with clients and trying to keep everything up to speed.
Just while we're on the subject, let's just clarify where you are in terms of your administrative suspension as we sit here today. It's my understanding that you've already completed many of the CLE hours that have been requested. Is that correct?
That's correct. I'm 4 hours short, and I didn't
That's
even
what I
realize
thought.
that. I thought I was actually caught up and didn't realize that the spillover was into this calendar year.
Yeah, exactly. The year changed. And then you just have some fees you need to take care of with the attorney registration folks in the clerk's office. Is that
Yes, and I've
correct?
talked to the girls over there several times, including just the other day. I call them the ladies over there. They've been very helpful. It's approximately $900 some odd right now.
Alrighty. So really that's what's left. It's a few hours of CLE and a few $100s. Maybe not a few, but several
Right.
$100s.
And I normally take approximately 25 hours of CLE a year. Obviously, I don't need that much for either state, but that's because of the complexity of the criminal practice. Unfortunately, I missed the fall one because of a conflict. I would have had 7 hours. I would have already had it done. I'm scheduled to take another 12 hours with Cactal and another 15 hours with the federal court in March and April. So
Is it fair
I would
to
say by
say-
April, I'm going to have enough CLEs to last for 3 years, but obviously I can't do that.
So is it fair to say that you anticipate being able to lift the administrative suspension in the near term?
I would say by the end of May, I should have everything in place, probably much sooner than that, but I don't want to put myself in a place.
Guaranteed. Okay,
Yes,
thank you.
yes.
That's helpful.
Obviously, Ms. Baird, again, some of this is going to be redundant, but I want to be a little more specific. I was monitored by Dave Johnson, and Dave is a federal criminal practitioner that I've also known for many, many years. So Carl Schopencotter in the disciplinary office over there recommended I go with Dave. I had tried to pick another friend of mine that was in civil practice. Carl suggested Dave's name. I'd forgotten all about. I didn't even think about Dave and didn't know he was doing monitoring. So this has worked out very well for me because I'm doing federal criminal cases primarily, and Dave's down there too. And so we get to talk a lot about all of these issues. Dave's, it's been wonderful. It's just, I'm sorry, I get a little emotional talking about it, but Dave's just been so awesome. Big help for me, and very supportive, because things have been difficult trying to rebuild my practice. I feel like I've got this scarlet letter on my forehead with this. The first thing you Google, when you Google my name, comes up as a license suspension in Missouri from 2007. So he's been very helpful. Dave recommended termination of the probation, and I have put in the application for that, and not yet heard back from the courts on that, on the Missouri Supreme Court. But Mr. Schopenhauer has already said that he anticipates also making that recommendation as well. So I should be off probation here shortly. I'm not seeing Dave right now. I'm basically done and just awaiting that. So what I have done and started the process back after the hearing in front of the committee in May is talking to Mr. Leininger, primarily just to see how I'm doing and how my practice is going in Missouri. And then meeting with Eric Kraft, and Eric was designated after the fact because Brian couldn't. And I apologize if I did not send you a copy of that. It went around for signatures, emails, or whatever, and I know Ann sent it to me, McDonald, with Caleb, the director. So I do have a copy of that, and she's spoken with Mr. Kraft as well, and I spoke with Eric as recently as last week.
What is your current practice? What are you doing?
Primarily federal criminal practice in the Western District of Missouri, some state work. I've got felonies in a number of counties over in Missouri, and then some municipal work. That's kind of been
it's criminal.
It's all criminal. That's been
Stakes are very high in criminal cases, as you know.
Especially in the federal practice. It's not for the faint of heart. I've been doing it since 1993, and I'm going to set my modesty aside. From 1999 to 2006, I was kind of a fixer. When the attorneys and the clients would get into it, because the attorneys wanted them to plead guilty, and the client did not want to plead guilty and wanted to go to trial, it was not uncommon for either the attorney wanting to withdraw or the client wanting to fire the attorney. Frankly, I don't like to criticize my peers, but I think it seems apparent sometimes, especially down there, that everybody wants to plea out their clients, put in a bill, get paid, and be done. And frankly, I've been very public about this. I'm not sure what they went to law school for, because Dr. Jack Balkin, one of my law professors, who is now a constitutional law professor at Yale University, always said, stand up and make the argument. And that's what I like to do.
Let me move you
Counsel,
over to, I'm sorry.
I was going to ask, before your time gets away from you, I want to make sure we hear from you on what you are proposing in terms of disposition. So I don't know if you want to address that now or take Justice Biles' question and then come back to that. Because you've been here this morning hearing our questions of Ms. Baird.
Right.
And trying to come up with some ideas. So if you want to take his question, I just want to make sure we come back to that one. Okay?
Yes, Your Honor.
Mine will help you out, because I want to talk about the mechanics of the order. And you've heard some discussion here about possibly the court's order saying that the administrative sanction condition of probation would be lifting the administrative sanction by a date certain. What date certain do you want? You mentioned probably being done by the end of May. I don't want to just hold you to that. I want to ask you the direct question. If we put in this order that it is a condition of probation that you be off Kansas administrative sanction by X date, what do you want X to be?
May 30th, and I'm going to ask this I'm not sure, I'm not familiar with this area of practice, obviously, but I've been thinking about all of this. If I get it done sooner, I don't know if the time could start then.
Well, all I'm saying is it gets done by X date.
May 31st.
Okay. And that'd mean that you'd pay up the $900 and you'd have your CLE.
That is correct, Your Honor. That should be more than adequate time. But I anticipate it happening much sooner.
And at that time, the 1-year suspension and 2-year supervised probation would go into effect. Are you in agreement with Ms. Baird on that?
Yes. Now, and this is where I kind of get confused about all of this. I know that there's been attorneys in Missouri and I think in Kansas, and correct me if I'm wrong, where the sanction was imposed, but then they were immediately placed on probation as though the suspension had almost been served. And I'm not sure if that's what, I was listening carefully to her and some of your questions and comments.
The suspension is usually stayed.
Thank you.
Right.
That's what and nobody used the word stayed, and so that's what I was looking for, the magic words. Thank you.
That's the same thing that's in the final hearing report.
Right.
Suspension would be suspended.
Right.
You'd go on probation. If you fail the probation, then you're back into suspension world.
Thank you. That's what, and I wasn't sure about all of that, and that was where I was sitting at the table. I was very confused. This is precisely what I would ask for as well. I know, and it was a different set of circumstances, but I know the 8th Circuit went back and made my suspension there retroactive, so I actually only served about 9 months suspension before I could reapply in that particular case. So when I was sitting at the table, that's what I was thinking about, the same thing. So I anticipate, and obviously I'm still going to meet with Mr. Kraft and Mr. Leininger, and I do want to address just quickly for the court to make it clear, I have not practiced law in Missouri. Anybody that calls me up, even clients, old clients, friends, whatever, I tell them, look, I cannot speak with you. All I can do is refer you to an attorney. I am absolutely militant about that. I tell them I don't want anybody ever inferring that I attempted to practice law or give anybody advice in the state of Kansas. And I want to make that clear to everybody today. And I've worked very hard at making sure, anybody who starts talking about Kansas, a problem, stop.
Did you have any further presentation?
Nothing further, Your Honor. Thank you very much.
Any more questions? Thank you, counsel. You're reserved 2 minutes for rebuttal.
Thank you, Chief Justice. Unless there are questions from the justices, I wouldn't add anything in rebuttal.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.